created in the year 1999, but it has retrospective effect. Retrospective effect means that it would be treated as if it has come into force from a back date, and that back date is the 1st of January 1985. So this ordinance has a retrospective effect. Now we have to look at the constitution of the Pakistan, which says that laws should not be retrospective in nature. So there might be a question that whether this would fall foul of the constitutional provisions of the law. So we can deal with that towards the end of the lecture. Section 3 gives this ordinance an overriding effect. Now Section 3 of the ordinance is also known as the non-obstantate laws. Non-obstante, I spell it out for you. The writing is legible. N-O-N, non-O-B-S-T-A-N-T-E. The non-obstantate laws. What this clause says that if there is any other law for the time being in force, for example, laws which provide indemnity or laws which provide protection, this law would prevail, and that law is not going to provide protection to the person. For example, if there is some law which says that if I keep this in my pocket, it would be not an offense. But since National Accountability Ordinance has come into force, that exemption or that relief that has been provided through that law would not be there, and this would override that law. So Section 3 has the overriding effect, and it is also known as the non-obstantate laws. Now we look at Section 4. Section 4 is the applicability of the law. This law is applicable throughout Pakistan. This law is applicable to all the citizens of Pakistan. There is a wide-held misconception that this law is only applicable to public servants. This is not the case. It is applicable to each and every person who is residing in Pakistan, who is a citizen of Pakistan. These are two different things. So it is applicable to all the citizens of Pakistan, a person who is legally residing in Pakistan, and it is applicable throughout Pakistan. Now we come to Section 5 of the ordinance. Section 5 of the ordinance gives a definition of different things. For example, what is a person? What is an accused? What is a judge? What is property? What is federal government? These are from A to I think V or X. Now you can have a look at the ordinance, and it would give you a detail as to the definitions provided. 5A is the accused. 5B is appropriate government. Then there are assets, associates, benami, and there are a number of definitions. The definitions that are most relevant to you is the definition of a judge. The judge of the accountability court would be a serving or a retired session judge with the eligibility of being appointed to the High Court. As soon as the district or the session judge has spent 5 years, he's eligible for appointment in the High Court. So in this case, a judge would be a district and session judge who has at least served for a period of 5 years. This is going to be a judge. Court means an accountability court. Accountability court judge is appointed by the President of Pakistan for a term of 3 years. There are a number of other definitions. I would not waste your time rather on the definitions. If there's some definition which is not clear, I'd be more than happy to dilate on that. Tenure of the judge is 5A. I've already given you the tenure, which is for 3 years. Then Section 6 deals with the appointment, deals with the National Accountability Ordinance. 6B deals with the appointment of Chairman NAB. Now, who's going to be appointed as Chairman NAB? A person who has either been a Grade 22 officer, has served as a Lieutenant General, has served as a judge of the Supreme Court of Pakistan or the Chief Justice of the relevant High Court. Not the judge, but the Chief Justice or the judge of the High Court. These are persons who are eligible for the appointment of Chairman NAB. Now, how is he going to be appointed? He's going to be appointed by the President of Pakistan, but there's going to be a consultative process between the leader of the House and the leader of the opposition. This is why when Fasi Bukhari Saab was appointed, there was an allegation, and probably Chaudhry Nisar, I was there. Chaudhry Nisar took that objection that there was no meaningful consultation with the leader of the opposition. And that is the ground on which the Supreme Court held that his appointment was void ab initio. Now, once the Chairman NAB is appointed, nobody can remove him except the Supreme Judicial Council. The procedure for it is provided in Article 209. The removal of a Chairman NAB is the same as that of any Supreme Court judge. So, there's going to be a Chief Justice of Pakistan, there's going to be High Court Chief Justices there, the Constitution of the Supreme Judicial Council, and apart from that, he cannot be removed by any one single person. So, the appointment is for a period of 4 years, and either he can resign or he can be removed by following the procedure provided under Article 209. So this is the appointment of a NAB chairman. Now we come to Section 6, which deals with the appointment of Deputy Chairman NAB. The Deputy Chairman NAB is to be appointed who has either held the office of Grade 21 officer, who had been a Major General, or who had been a Judge of the High Court. This is the criteria for the appointment of Deputy Chairman NAB. In the absence of Chairman NAB, Deputy Chairman NAB would perform his functions. But those functions he cannot perform unless and until he has been delegated with that function. We cannot cheat upon the law. There was this case, probably Al Jihad Trust was the case, in which they did not appoint. Now I would give you the citations as well. PLD 2011 something. I would give you the exact citation. They did not appoint Chairman NAB, and they were running the day-to-day affairs of NAB through Deputy Chairman NAB. The court held that that cannot be done. So once the Chairman NAB is there and he absents himself, that is where the Deputy Chairman NAB would perform his functions. And we cannot cheat upon the law and simply appoint Deputy Chairman NAB and not appoint Chairman NAB and continue with the functions of NAB. Section 8. Section 8 of the National Accountability Ordinance deals with the appointment of a Prosecutor General. A Prosecutor General is a person who is fit to be appointed as a judge of the Supreme Court. That is, he has 15 years, at least 15 years of practice as an advocate High Court. My learned friend fulfills that criteria and he can be appointed as Prosecutor General NAB. Kundi sahab, aapko keh raha hu. Acha. His appointment is for a period of 3 years. Again, the removal procedure is twofold. Either, not twofold, there are two ways he can go home. First, he can resign and leave the office, or we again have the procedure provided under Article 209 of the Constitution. He is appointed he's appointed by the President, but with consultation with Chairman NAB. That is his appointment procedure. Now we come to the most important section, that is Section 9. Section 9 of the National Accountability Ordinance provides for the punishments that are there in the ordinance. Now this is a detailed one, that's why I'm having a look at the book. It says that a holder of a public office or any other person is said to commit or have committed the offense of corruption and corrupt practices if, number one, if he accepts or obtains from any person or offers any gratification directly or indirectly other than legal remuneration as a motive or reward such as is specified in Section 161. We are all aware, mostly people involved in criminal litigation, that 161 deals with public servants receiving illegal gratification. So this is akin to that section, but it also includes persons which are not holders of public office. So this is the distinction between this law. This is special law. That is general law. Wherever there's a conflict, we are well aware, whenever there's a conflict between the two laws, which law would prevail? The special law would prevail. So for doing or forbidding, so if he takes or accepts for doing something or from restricting himself from something, that is an offense under the National Accountability Ordinance. 1. 2. If he accepts or obtains or offers any valuable thing without consideration. For example, somebody gives me this phone, and I am in a position to do or to forbear from doing something. For example, I am a public servant, I am an assistant commissioner. I accept this phone and I stop the legal proceedings against an accused persons. I would fall foul of the provisions of section 9.2 of the ordinance, and it falls squarely within the ambit of NAB. Section 9.3. Section 9.3 says that if he dishonestly or fraudulently misappropriates or otherwise converts for his own use or for the use of any other person any property entrusted to him. This is akin to criminal breach of trust. For example, I have been given certain assets as a fiduciary, or I have to, for example, I'm secretary of the bar, library secretary of the bar. And instead of putting these books over here in these shelves, I take them home. So I have converted for my use property which has been entrusted to me. This is an example where I've fallen foul of section 9.3 of the ordinance. 9.4, this is important. If he by corrupt, dishonest or illegal means obtains or seek to obtain for himself or for his spouse or dependent or any other person any property, valuable thing. So this would almost be present in each and every case where there's an allegation of corruption, unless that is a case of misuse of authority simpliciter. So whenever there would be a charge of corruption, or whenever the prosecution is going to allege that he's made something out of the transaction, section 9.4 of the National Accountability Ordinance would always be there. So this is the most commonly referred to and used section in the references. So this is important. There's case law to it, which we are going to discuss towards the end. Section 5, 9.5. If he or any of his dependents or benamidar owns, possess, right or title in any asset, power of attorney in respect of any asset, or pecuniary sources disproportionate to his known sources of income, or if he is living beyond the known sources of income. For example, I am employed for 100,000 rupees. My utility bills exceed that amount. I drive a car which is not commensurate to the earning that I get. This is where I have committed an offense, or allegedly committed an offense, which falls foul of section 9.5 of the National Accountability Ordinance. I am living beyond my means. So this is an offense. Section 9.6. Now this is also a very commonly used offense, misuse of authority. Now misuse of authority, simple misuse of authority, the courts have on a number of occasions held, is very difficult to prove unless and until there is a combination of some advantage gained, because then the offense lacks motive, reason. Why would I act in a certain fashion if I have not obtained any advantage out of that transaction? So misuse of authority is to be coupled with pecuniary advantage gained. Otherwise, it would not be an offense. The language is also very clear. If he misuses his authority so as to gain any benefit for himself or any other person, or renders or attempts to render, or willfully fails to exercise authority to prevent the grant or rendition of any undue benefit or favor which he could have prevented by exercising his authority. So, if he misuses his authority so as to gain any benefit, simpliciter misuse of authority does not fall within the definition of 9(6). So if somebody alleges that a government servant has done something which was beyond his authority, or he has done something which is contradictory to the powers given to him, we also have to prove that as a result of that, he has gained something for himself. So these are the elements which are there. You see, when we see crime, there are two basic things that we look at. First is the mens rea, and second is the actus reus. This falls within the actus reus of the crime. If he has not obtained anything for himself, one element of the actus reus is missing, and since there's no coincidence of mens rea and actus reus, there would be no crime. Now we have 9(7). If he issues any SRO or a notification by which anyone has obtained any advantage, and that is illegal advantage, I can be held liable. But this is rarely used. Then we have 9(8). If he commits the offense of willful default. Willful default is also defined in section 5R of the ordinance. Willful default is that I have taken money from a financial institution, from a bank, from a government department, and despite a notice for the return of the money or time lapse for the return of money, I do not return back that amount. So this is known as willful default, which is an offense under the ordinance. It is there in the schedule of the ordinance. It has been defined over here, but willful default is in the schedule which is pursuant to section 10B of the National Accountability Ordinance. We're going to look at it in a while. Then we have section 9(9). If he commits the offense of cheating as defined in section 415 of the PPC, and thereby dishonestly induces members of the public at large to deliver any property. Now these Ponzi schemes, these schemes where a society takes money from the public at large to build something, to give them flats, for example, houses, or I say you give me 10,000 rupees and by the end of the year I would return you 20,000 rupees. This would fall within the definition of section 9(9). So I dishonestly take the property from you and then I keep it to myself. This offense is usually employed in Ponzi schemes. Ponzi schemes are schemes, ये डबल शाह वाली जो स्कीम है, ये Ponzi schemes कहलाती हैं. सबसे पहले जिसने किया था उसका मेरा ख्याल है कोई नाम में Ponzi शोंजी आता था, तो ये Ponzi scheme के तौर पर मशहूर है. Then we have 9(10). If he commits the offense of criminal breach of trust, as I've already, the definition is there, I think in 403, and the punishment is there in 406, criminal breach of trust. If he commits criminal breach of trust, he's again liable and falls within the ambit of the National Accountability Ordinance. Then we have 11. If he, in his capacity as a banker, merchant, factor, broker, attorney, or agent, commits criminal breach of trust, it is again, जैसे 406 में था तो 408 में, 409 में, जैसे जाते हैं banker, servant, इनकी definitions आती हैं इसी तरह. Then we have 9(12). 9(12) is aiding, abetting, procuring, or attempting to do something. Now, these offences are also known as inchoate offences. लिख लें इसको. ये term शायद आप बहुत ज़्यादा familiar ना हो. Inchoate offences, कि आप कोई काम करने लगते हैं, you're about to do something towards a crime, and that embarking upon or trying to do something in itself is a crime. For example, a person is beating A is beating B, and C says, balle balle all mothers. This is encouragement. This is inchoate offense. He would be treated as an accomplice तो complicity आएगी. Inchoate offenses को कहते हैं aiding, abetting, encouraging और procuring something. Aid is कि मैंने उसकी टांग पकड़ी हुई आप मार लें. Abet is I incite him कि यार फला फला ऐसा है, इसको जाकर दो एक मुक्के तो लगाओ. This is abetting. Encouraging is हाँ भाई और मार रहा है. And attempting to do something. These are known as inchoate offenses. So a person who is guilty of an inchoate offense would be treated at par with the principal offender and would have the same, can be liable, can be punished up to the same term of punishment as the principal offender. So now we have section 10. Section 10 provides for the punishment we have in the National Accountability Ordinance. The maximum punishment is 14 years and forfeiture of the assets which are beyond the known sources of his income. All those assets would be forfeited. और दूसरी एक बात और चीज नोट कर लें. सेक्शन 10 जरा सख्त भी है. रिमिशंस जो होती हैं नॉर्मल क्रिमिनल ट्रायल में, फॉर एग्जांपल फॉर गुड बिहेवियर, फॉर एग्जांपल नेशनल हॉलीडेज, फॉर एग्जांपल और गवर्नमेंट रिमिशंस देती है. दोज आर नॉट अवेलेबल टू एक्यूज ऑफ नेशनल अकाउंटेबिलिटी ऑर्डिनेंस. सो दिस इज harder in nature, more severe in nature than the normal criminal law. मैंने 10B का आपको बता दिया. 10B के तहत शेड्यूल बना हुआ, which also provides for certain offences. For example, the offence of willful default, जैसे 5R का. Now we have section 11, imposition of fine. How much fine is to be imposed on a person who is found guilty? Not less than what he has gained. So this again is a misconception कि 2.5 करोड़ का allegation था, प्रूव हुआ, 20 करोड़ लेके उसको फारिग कर दिया. ऐसा कभी नहीं होता. पूरे के पूरे पैसे उससे रिकवर करेंगे, वो पैसे रिकवर होंगे, उसके बाद ही let off the hook. ठीक है. Section 11 says that the fine would not be less than the pecuniary advantage gained by the accused. So this is very clear. Section 12. Section 12 deals with the freezing of the assets. Now there are two ways assets can be freezed. Now the number of properties: immovable property, movable property, intellectual property. Assets कैसे freeze होंगे? Through attachment, through confiscation. जहाँ movable property उसको confiscate कर लेंगे. जहाँ immovable property है वो attach हो जाएगी. चेयरमैन नैब कर सकता है, कोर्ट कर सकती. बट एनी प्रॉपर्टी फ्रोजन बाय चेयरमैन नैब वुड नॉट लास्ट फॉर मोर देन 15 days एंड अप्रूवल ऑफ द कोर्ट इज रिक्वायर्ड. सो इफ certain property is frozen by chairman NAB, after 15 days, if the approval of the court is not there, that would not be deemed to be frozen anymore. अच्छा जी, इनकी property है, freeze की है. I am a co-owner. I am an innocent person. But that property has been attached. I can file objections to that freezing order. Section 13 deals with those objection petitions. The first objection petition would be filed before the accountability court. And if he does not decide in your favor, you'd go and file a writ. High Court. Now, bear in mind that Section 9B provided for a bar on bails, that an accused person cannot be granted bail under this law. This remained in force for quite a period of time till we had the case of Khan Asfandyar Wali case versus the Federation of Pakistan. The citation for the case is 2000. There's a very important case which you should note down because this is the primary case. Written somewhere. हाँ ठीक है, वो मैं आपको बता देता हूँ. 2001 PLD 2001 Supreme Court 607. Now this is a bulky case. This has more than 200, almost 300 pages, but it clarifies the NAB law. It clarifies some of the misconceptions there. It clarifies some of the fundamental rights which were taken away by NAB but were provided by the constitutional courts. So 9B restricted the courts from giving a bail to any person who was accused under this ordinance. But the court held in this case that since liberty of a person is a fundamental right, it cannot be taken away from the court. It cannot be taken away from the accused. And they granted bail in the writ jurisdiction. So till date, whenever we're going to file a bail, it is going to be under Article 199 of the Constitution. And a division bench of the High Court is going to listen to that bail. So a DB would sit in order to listen to that bail. आपने तो पूछा? अच्छा. Well, we have a 20 minutes towards the end of the. ठीक है. वालेकुम अस्सलाम. So दास साहब क्या हाल है? अच्छा. We were section 13 objections की बात कर रहे थे. Section 14 draconian provision of NAB. Presumption of innocence has been reversed. You are not presumed to be innocent until proven guilty. You're guilty unless and until you prove that you're innocent. We have this cardinal principle in law that accused is the favorite child of law. Blue-eyed baby, darling. These are the words that are used in the judgments. You're no more the darling. You are a culprit unless and until you prove that the assets that I've made, that the amount that I have in my bank is through lawful resource. So section 14 says that you have to prove if there are assets beyond the known sources of income. Now distinguish this with a complete shift. This is not a complete shift of the burden of proof. First of all, the prosecution has to prove that he owns assets which are beyond the known sources of income. And then you have to justify that no, these assets were made legally. That is, when we look at the Panama case, that is the controversy over there. First, they had to prove. I don't have any affiliations with any political party. I'm just giving a brief lecture on the law. It was a fault there. The prosecution had to prove that these properties belong to this person before he could be convicted under because of the reverse presumption. The prima facie burden is still on the prosecution to prove that this is the case. These assets are owned by this person. And then he has to prove that these assets were made through lawful sources. So section 14 deals with the presumption. We have one more thing in section 14. Now, this is basically presumption. Then there are disqualifications. What if you are accused of an offense under section 9 of the ordinance? You are disqualified. What are those disqualifications? You cannot hold a public office for 10 years. You cannot obtain a bank loan for 10 years. You cannot contest election for 10 years. There's a disqualification. And that disqualification serves a purpose. In criminal law, we have different purposes. Deterrence is one of the purposes. Reformation is one of the purposes. Saving the society from that evil is one of the purposes. So here we see both. Deterrence and keeping the evil away from the society. He cannot represent you. He cannot administer you. He cannot take advantage of the normal things that a normal citizen would do. So this is the disqualification. Section 15 deals with disqualification. Section 16 deals with the trial of the offences. It says that this would be an expeditious trial. I have yet to see a trial conclude in 30 days. It says 30 days my trial conclude karenge. Unimaginable, unthinkable. You look at NAB references, those are 10,000 pages. You say the conclusion of a trial, no matter how dedicated, hard-working person you are, you cannot read those 10,000 pages in 30 days. If you read around 100 pages per day, with understanding, the total would be somewhere around 3,000 pages. So you read like 300 pages a day, and you would be simply be able to read the case that is made out against you. What to say of conclusion of a trial in 30 days. See, when we look at the system, we have to appreciate that it is because of some unrealistic expectations or targets that are provided in the law. For example, if somebody is contesting elections, he says, all right, this is what I'm going to do. I am going to get each and every one of you a retainership. Not possible. These are tall claims. And tall claims, whether in the statute, whether in political campaigns, whether in general conversation, would lead to frustration. People would say, you've not been able to deliver as per our expectations. So creating expectations which are not normal expectations would lead to criticism. This government is facing this criticism because it gave out an impression that we're going to remove all these difficulties by one stroke of a pen. They were not able to do it. So these are unrealistic expectations. The statute should be pragmatic, practical, should keep in mind the timelines as well. 30 days can never be achieved. A trial can, notices are not served to the accused in 30 days. What to say of conclusion of a trial? So, Section 16 deals with trial of the offences. Section 16 also deals with where the trial is going to commence. Now, this is the beauty of NAB. In journal, I think it's 177 CRPC that wherever the crime is committed, it's going to be tried there, it's going to be registered there. ऐसा ही है ना? 177 ही है ना? 177 ही है
CRPC में.
CRPC में. क्राइम इस्लामाबाद में कमिट होता है, कोर्ट बलोचिस्तान की भी कॉग्निसेंस ले सकती है. So any court anywhere in Pakistan can take cognizance and try the accused person. There's no limitation. The chairman NAB has to say, okay, all right, this court is going to. That's why we see certain cases made against former president, former premier of Pakistan being tried in Islamabad and not in Sindh. Now he has to give consideration, weight to a number of things. The influence of the accused person is so influential that a trial cannot be concluded fairly and impartially at a certain place. That provision is there to cater to that need. Some people are very powerful. Some witnesses are intimidated. The judges are intimidated at times. So, a NAB trial can take place anywhere in Pakistan. This is Section 16D, I suppose. Yes. No, 16B. Sorry. Now we have Section 17. What is the procedure that we're going to adopt in NAB? The procedure, the code would apply. Section 5, in the definition it says the code would apply. And what is the code? Code is the Criminal Procedure Code. So primarily, NAB is going to be dealt with according to the provisions of CRPC. The substantive law is there. This is also substantive and ejective law, but the ejective law would be the CRPC. The procedure law would be CRPC. But it can be dispensed with. The court, if it thinks fit that there are certain shortcomings, can apply CPC as well to it, or can completely dispense away with the Criminal Procedure Code to cater to the specific issues, contingencies in that case. Section 18, cognizance. Section 18 is cognizance. How is NAB to take cognizance of offences? There are three ways it can take cognizance. Matter is referred to by the government. There is a private complaint against a person, it can take cognizance. Suo moto action. The chairman NAB on his own initiative can take action. These are the three ways NAB takes cognizance of matters. What is the normal procedure in NAB? Now, this is not there in the book. The first stage is the complaint verification stage, which is known as the CV. A complaint is made. What do they verify? It should not be anonymous. Does it have certain prima facie evidence in that complaint? There's no malice. They evaluate that. This is the complaint verification stage. So this is the first stage your complaint goes through. The complaint verification stage. Then comes the inquiry. They inquire into the matter. Then there is the stage of inquiry ke baad investigation. And then finally we have the filing of the reference. So complaint verification stage, inquiry stage, investigation stage, and the filing of the reference. VR can only be done till the inquiry stage. Once it has proceeded from the inquiry stage to the investigation stage, now you can only enter into an agreement with NAB, and that would be a plea bargain. It would not be a VR. And I have already explained the difference between the two. One is I voluntarily submit that, all right, there's a complaint against me, I've made such and such illegal gains, and I'm willing to return it without wasting the time of the prosecution, without wasting their resources, without wasting their energy. All right, the law says you're off the hook, return us the money and go. There is no legal implication. Now, whether that should be the case or not is a different thing. But what is the law? I'm talking about what the law is, not what it ought to be. 9b, once the stage of inquiry is crossed and we come into the realm of investigation, then if there's a compromise or there's an agreement for the return of the money, that would be termed as a plea bargain. And if a person enters into plea bargain, he would be treated as a deemed convict. He will not be incarcerated, he will not go to jail, but all the implications of a convicted person would apply on him. The disqualifications, no loan, no elections, no public office. There would be a bar on it. अच्छा जी, ये cognizance की बात थी. Section 18G के तहत reference बनता है. Chairman NAB, after evaluating all the evidence, after looking at all the documents, after inquiring into the matter, if he thinks that a case is made out, he makes a reference. ठीक है? हाँ, अगर उसको ये लगे कि the case is not made out, then he can refer the matter to the court for the acquittal of the person. उसको बीच में निकाल सकते हैं. ठीक? अच्छा जी. 18H ये कहता है कि if a complaint is inquired into and investigated by NAB and it is concluded that the complaint received a prima facie frivolous complaint, an action can be taken against the person who's filed that frivolous complaint. So these are the two most important. There might be other important things in 18, but 18G का reference है, 18H का. जैसे 182 की कार्रवाई होती नहीं है, आज तक कम ही देखी होगी कि वो कहे कि जी, लेकिन ये उनका प्रेरोगेटिव है. प्रेरोगेटिव अगर पुलिस में हमने किया है तो प्रेरोगेटिव पुलिस वाले का. अगर हमने नैब का किया तो प्रेरोगेटिव नैब का है कि वो देखे कि दिस वाज अ फ्रिवलस कंप्लेंट and they have to take action. You can only intimate them or request them. You don't have a prerogative to file something against the person who is complained against you. Then we have the famous call-up notice, section 19. Power to call for information. ये notices होते हैं मुख्तलिफ लोगों को जाते हैं. People who are acquainted with the facts of the case, people who have participated in the commission of the offense, and the accused himself. ये सालों को call-up notices जाते हैं. Call-up notices, the courts have consistently held must contain the crux of the allegation against the person. It cannot be very generic in nature. Okay, gee, you've committed some offense, so why don't you show up and have a cup of tea with us? No. This is not a call-up notice. Call-up notice would give you a brief reason of calling you. For example, X, Y, Z, in that area, you had launched a scheme, and as a result, the people have suffered this loss, and you are either acquainted with the information or you were a participant in the commission of that offense. It should have a detail in it. Similar to the grounds of arrest. When the person is arrested, it would contain the ingredients, the reasons why he has been arrested, the offense that he has committed, the reason why it is necessary to arrest that person. For example, they can say you are a British national, there is an apprehension that you would abscond. So this is one of the reasons in the grounds of arrest. So similarly, when a section 19 notice is served, they're going to provide you with the basic set of allegations against you and the reason that why they're calling you. If the call-up notice is very general in nature, you can challenge it in the High Court. And then again, we're going to go in the writ jurisdiction of the High Court. Section 20. I would like to have a glass of water, Bilal sir, for the pani level. If you would excuse me for 2 minutes.
Sir, we have so many questions.
I have a good 20 minutes for you.
ये तो दे दीजिएगा जाते हो ना
This is related to all of us.
या सबकी तरफ से
Helpful for all of us. शायद.
अभी तो घंटा है अभी तो. I am speeding up the process because obviously I have to cover the whole of the ordinance. So अगर आपको लगे ना कि ज़्यादा speed के साथ हो गया तो you can individually come up to me and I'd be happy to give you the case law, the details into it as well. Section 20. Section 20 deals with the reporting of suspicious financial transactions. Now this is a duty that has been imposed on financial institutions, banking institutions, certain government organizations, that they have to report suspicious transactions. For example, there's a transaction in my account of 20 million rupees out of nowhere. The bank has to report this. An STR is generated, suspicious transaction report. Now, this is the Financial Crimes Investigation Wing in NAB which deals with this. I was heading it when I was in NAB. Financial Crimes Investigation Wing, FCIW कहलाता है. ये banks के साथ, financial institutions के साथ liaison रखते हैं. So any out of the ordinary transaction is to be reported by them. This is a duty that has been imposed by law by virtue of section 20 of the ordinance. Section 21, International Cooperation Wing and a request for mutual legal assistance. I can write to different jurisdictions to help me out. I have been given this power through a statute. मेरा accused UK में चला गया है, किसी और मुल्क में चला गया है. I am legally empowered to write to those law enforcement agencies to seek information, to seek help, so that the accused may be brought back home. So हम कहते हैं जी वो बाहर चला गया तो हमारे पास क्या राइट है? हमारे पास सेक्शन 21 अवेलेबल है. फिर चेयरमैन NAB has powers to request help from any of the law enforcement agencies within Pakistan. It is just not NAB. He can ask from MI, he can ask from IB, he can ask from ISI to help him out. So all those agencies which are there for the law enforcement would help him. And this is because of section 21 of the ordinance. Section 22, jurisdiction. He can, any person, investigate any person or authority. So he has jurisdiction throughout Pakistan to investigate, to inquire into things. Transfer of property void pending investigation. Now what happens is, there's a complaint against me. And I anticipate that I would be found guilty. I would be found guilty. In anticipation, I sell off my property, or I try to dispose of with that property. The law says that I cannot do it, and I have been forbidden by law to do it. And any transfer of property during that period of time when I am being investigated would be treated as void. So a good title would not be passed to the third person. And a third person cannot say that I am a bona fide purchaser for value. This law would hamper him. A bona fide purchaser for value is the blue-eyed baby of law. But here, this principle is not applicable. So if there's an investigation going on, there's an inquiry against a person, transfer of property by him would by law be treated as void. This would be void ab initio. A transfer cannot be made. Section 24 deals with arrests. At what time can a person be arrested? He can be arrested either during the inquiry, investigation stage, or even after filing of the reference. 156 हम देखते हैं ना investigation का, पे re-investigation भी हो सकती है. So even after the filing of the reference, there is still a possibility that I find something new in that thing, and I can still arrest the person. So a person, this was not there. This came into being after, this was an amendment in 2002, and they added the words even after the filing of the reference. So a person can be arrested during the inquiry stage, or the investigation stage, or even after the filing of the reference. But keep that in mind that there are reasons why they included it. They primarily included it because there were certain cases which were transferred from other agencies to NAB. FIA was conducting a trial. 16A की provision देख लीजिए. I've missed out on something. NAB can write to other courts. A NAB court can write to a court of a special judge saying that this crime falls within our ambit, so the case may be transferred. So any transferred case would be deemed as a reference against a person. तो अब वो ट्रांसफर तो हो गया, तो आपने इन्वेस्टिगेट तो NAB ने किया नहीं. So even after the filing of the reference caters to that need. Okay, that will be treated as a reference. ठीक है जी. So arrest के ऊपर आ गया. Grounds of arrest provide करेंगे. Fundamental right है. I would give you guys 70-80 cases which are relevant to this. But let me finish this. फिर मैं आपको वो उसकी hard copy दे दूंगा. उसको पढ़ लीजिएगा. जो primary case है वो मैंने आपको बता दिया, आसफंद यार वाली का case. If you read this case, you're good to go. क्या बात हो रही थी? Arrest की. Grounds of arrest provide करेंगे. It is my fundamental right that at the time that I'm arrested, I be told why I'm being arrested. The reason, the offense that I've committed. ठीक है जनाब? Section 25, the famous VR and the plea bargain. Section 25A of the National Accountability Ordinance deals with voluntary return. I've already explained that if there's an allegation against me, a complaint is filed against me, NAB writes or calls me and I admit my guilt and return the money, this would be treated as a VR. There are no strings attached. I'm not a convict. I return the money and go back home scot-free. 25B deals with plea bargain. Plea bargain is again, it has crossed the inquiry stage, entered the investigation stage, and now I've, after wasting some time, think that I should settle. And I settle. Even after my conviction at the appeal stage, I can enter into a plea bargain. Like this. This is important. I've been convicted. There's an appeal of Section 32 pending. I can still write to NAB and say, all right, I'm guilty. Let's settle. It will be treated as a plea bargain. I don't recall any 25C. Let's see. I don't think there's any 25C. Huh? 25B है. होगा शायद. C है. The amount deposited by accused with the NAB shall be transferred to the federal government. जाएगा federal government के पास जाएगा. अच्छा ये भी एक misconception है कि जी NAB वाले बड़ी याशियां करते हैं. पैसे आ गए 2,500 रुपये मेरे पास नहीं आए. फेडरल गवर्नमेंट में जाएंगे. फेडरल गवर्नमेंट NAB को अकॉर्डिंगली जितना समझती है उतना रिलीज करेगा जितना अमाउंट एक्सपेंस आया, लाइक एनी अदर गवर्नमेंट डिपार्टमेंट. सो इट वुड नॉट बी चेयरमैन NAB हु रिसीव्स द मनी. इट वुड गो इन द किटी ऑफ द नेशनल गवर्नमेंट. अच्छा जी 25 ये हो गया. 26 पार्डन. ये कानून थोड़ा डिफरेंट है. पार्डन का बेसिक उसूल ये है कि a person who has been pardoned would remain in jail till the conclusion of the trial. There is a normal जो है 337 है. मैडम क्रिमिनल प्रैक्टिस को याद नहीं आ रहा. पार्डन का यही है मेरे ख्याल से. इस केस में if a pardon is granted to a person, he is released before the conclusion of the trial. This is different in nature too. Now, if somebody asks you what are the distinguishing features of NAB law, or what is something which is novel in NAB law which is not there in your normal CRPC, these are the distinctions. We don't have voluntary return or plea bargain in the normal criminal procedure. We don't have the release of a person or granting the bail of a person who has been pardoned in the normal CRPC. It is after the conclusion of the trial that he would be released. So section 26 deals with pardon. 27. Is power to seek assistance. Here again, it's for mutual legal assistance के साथ it will be read with section 27. मैं assistance ले सकता हूँ किसी भी law enforcement agency से within Pakistan, legally entitled to do it. Sir, please have a seat. Thank you. 28. ये अपॉइंटमेंट से रिलेटेड है कि NAB के ऑफिसर्स कैसे अपॉइंट होंगे. अच्छा आप ये समझिए NAB में है क्या. NAB is dichotomy. One is the prosecution side, the other is the administration. हम कहते हैं कि अच्छा जी वकील जाएगा तो वो असिस्टेंट डायरेक्टर अपॉइंट होगा नहीं. Unless and until he goes through that regular procedure, he would be appointed as a prosecutor. और वकील को ज़ेब भी यही देता है कि if he wants to remain in practice, he should be appointed as a prosecutor and not in the regular cadre. If he is appointed in a regular cadre, he would have to surrender his license. So the dichotomy is, one is the prosecution. The chairman NAB is the linchpin. He is there, he is the head. There's no doubt about it. But the prosecutors are under the prosecutor general. So that's why I say that there's a dichotomy, the regular cadre and the prosecution side. And there's always a tiff between the two. Because lawyers don't agree that quickly. Lawyers they have their own independent view of things. That's why there's always a fight between them. The officer says, I think there's sufficient evidence. He says, no. Legally, I think there's insufficient evidence against it. So, एक prosecution side है, एक आपकी जो regular cadre है इसका. ठीक? 28 deals with the appointment of the officers, which I think you would hardly ever use. अच्छा जी. इसमें एक बड़ा इंटरेस्टिंग बात और भी है कि an accused person is a competent witness. ये देखिएगा. I'm going to read it aloud. An accused person shall be a competent witness for the defense and may give evidence on oath in disproof of the charges made against him. He would not be compelled. वो constitution हमारी एक protection है. 30. False evidence. False evidence जो देगा उसकी punishment provided है और कोर्ट उसको ट्राई कर सकती है. 31A. This provision says that if you abscond absconding itself has been made a crime. This is 31A. 3 साल सजा है इसकी. लेकिन इसको recently the Supreme Court of Pakistan has held that this is against the constitutional rights or the fundamental rights that have been given to the accused person. There are a number of reasons why people abscond. And it's not necessary that he has absconded because he was guilty. There are other reasons. ये हो गया जी 31A. अब आ जाते हैं अपील्स के ऊपर. 31A के बाद शायद कोई 2-4 मोटी मोटी चीजें हों. हाँ जी. (31B) provides for withdrawal from prosecution. ये पावर प्रोसिक्यूटर जनरल की है कि if the prosecutor general feels that the case is not made out, he can always write to the court and withdraw from the prosecution. जैसे एडवोकेट जनरल ऑफिस है, जैसे आपके यहाँ पे विड्रॉ कर सकते हैं कि जी हम समझते हैं ये केस नहीं बनता, प्रोसिक्यूशन नैब की ये काम कर सकते हैं. 31C ये थोड़ा ही है, ये इतना रेलेवेंट नहीं है. अपील्स पे आ जाए. 32 इसका अपील के दिन जो प्रोवाइडेड है वो बहुत थोड़े हैं. As soon as you're convicted, you have only 10 days to file an appeal. 10 दिनों के अंदर अंदर आपने अपील फाइल करनी है. No appeal shall lie against an interlocutory order, against an interim order. No revision is competent against an interlocutory or interim order. क्या करेंगे? रिट में जाएंगे. Interlocutory orders क्या होते हैं? Which do not conclusively conclude a case. जो miscellaneous एक बात होती है, या उसमें जो ancillary एक बात होती है, या incidental कोई चीज है उसको देख रहे हैं. So no revision, no appeal against an interlocutory order. We're going to go in the writ jurisdiction. Now we have 33. ट्रांसफर हो सकती हैं प्रोसीडिंग्स ऑब्वियसली, एक कोर्ट से दूसरे कोर्ट प्रोसीडिंग्स. अगर प्रोविंस से दूसरे प्रोविंस की कोर्ट में भेजनी है तो अप्रूव आपने सुप्रीम कोर्ट को लिखना है, और अगर विद इन द प्रोविंस करना है तो रेलेवेंट हाई कोर्ट को करेंगे. और ये राइट बोथ द प्रोसिक्यूशन and the accused has the right to do this, and accused can also agitate this matter before the Supreme Court or the High Court to transfer his case. Then we have witness protection. वो भी देख लीजिएगा, इसमें है shielding of witnesses. The powerful people who have committed corruption of billions of rupees. Shielding of witness protection program भी मौजूद है. फिर एक चीज जरा इसमें देखिएगा कि नैब का एक पर्पस अवेयरनेस क्रिएट करना भी है. ANP है, अवेयरनेस एंड प्रिवेंशन. इसका अलग डिपार्टमेंट है नैब में. ये जो आप मूवी देखने जाते हैं तो सबसे पहले आप बदमजा हो जाते हैं देख के, या खुश हो जाते होंगे कि जी करप्शन बहुत बड़ा जुर्म है, ये उसके एम्बिट पे आती. अवेयरनेस एंड प्रिवेंशन आपको मौसूल होता है गवर्नमेंट ऑफ पाकिस्तान. करप्शन बहुत गलत चीज है, नो डाउट गलत चीज है. अनफॉर्चुनेट, अब कंक्लूड करने लगे. अनफॉर्चुनेट चीज मैं आपको बताऊं, किसी जमाने में पिक पॉकेटिंग की सजा होती थी फांसी. उधर मजमा इकट्ठा हो जाता था और सबसे ज्यादा पिक पॉकेटिंग उधर होती थी उस फांसी की सजा को देखने के लिए. नाउ द डिलेमा, it is a very sorry state of affairs. Anti-corruption agencies, anti-corruption watchdog, इसमें जितनी करप्शन होती है अलामान अलफीज. विक्टिमाइजेशन है, पॉलिटिकल विक्टिमाइजेशन. आप इन्वेस्टिगेट करें इनको, डिप्टी डायरेक्टर्स को देखें, एडिशनल डायरेक्टर्स को देखें, करोड़ों अरबों रुपए की प्रॉपर्टी आपको मिल जाएगी.
तो सर आप कहना चाहते हैं ये मांडवी वाला साहब जो कह रहे हैं 2-4 हफ्तों से, कल उन्होंने प्रेस कॉन्फ्रेंस की है, दे आर राइट.
देखे ना, वन ऑफ द क्रिटिसिज्म्स ऑफ नैब इज दैट दिस इज कंसंट्रेशन ऑफ पावर्स. आप इन्वेस्टिगेट भी खुद कर रहे हैं, अरेस्ट भी खुद कर रहे हैं, टाइम्स जजमेंट भी खुद पास कर रहे हैं. वो है ना, power corrupts and absolute power corrupts absolutely. This is a classic example of an absolute corruption of power. There's a draconian law. Now, what should be done? The court should come into field, provide protection to people who are genuine people. Well, this is all. I hope that I have a lot of questions to face. There would be another couple of sections there which are not most commonly used, but this is the crux of NAB law. So if you have any questions, if you have any queries, I'll be more than happy to answer them over here. Sir. Welcome,